an application which I filed in a 138 proceeding seeking interim compensation 140 under 143A. The Honorable Trial Court has come to a conclusion, my lord, has prejudged the issue and come to a conclusion that the check was given towards a time bar debt, and there is nothing to unearth. That is the observation made.
The check was dishonored on account of it being quote unquote a non-CTS check. The complainant files an application under section 143A of the Act seeking interim compensation at 20% as obtaining under the statute.
The order impugned is, my lord, an application which I filed in a 138 proceeding seeking interim compensation under 143A. The Honorable Trial Court has come to a conclusion, my lord, has prejudged the issue and come to a conclusion that the check was given towards a time bar debt, and there is nothing to unearth. That is the observation made. My lord should find it at page number 36.
We'll send it back. That cannot be the ground on which 143A can be rejected. The petitioner is the petitioner is before this court calling in question an order dated
T27-2022.
Where is your prayer?
T27-2020.
My lord, prayer is at page number 12, my lord.
An order dated 22/7/2022 passed on an application filed under section 143A by the present petitioner, the complainant in the case at hand. Heard so and so. Facts in brief, germane, are as follows. The complainant and the respondent accused have a transaction. In furtherance of the said transaction, it transpires that a check was issued by the respondent accused in favor of the petitioner. The check was dishonored on account of it being quote unquote a non-CTS check. The complaint is registered by the petitioner before the learned magistrate invoking section 200 of the CRPC. The matter was pending as CC 20456 of 2021. The issue in the list does not concern the merit of the matter. The complainant files an application under section 143A of the Act seeking interim compensation at 20% as obtaining under the statute. The accused files his objections. The application comes to be rejected on 22/7/2022, the rejection of which has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the application could not have been rejected on getting into the merit of the matter. The parameters of consideration of the application is considered by this court in plethora of cases. He would seek reconsideration of the application at the hands of the concerned court. The learned counsel appearing for the respondent accused, though would defend the order that is passed by the court, would however submit that it is not in consonance with the guidelines so laid down by this court in case of Madam Dairy Ice Cream and on judgment is Dairy Ice Cream and now laid first fold, second fold. I have given my anxious considerations also. The aforenarrated facts are not in dispute. An application comes to be filed by the petitioner under section 143A of the Negotiable Instruments Act seeking 20% of the check amount as interim compensation during the pendency of the proceedings before the concerned court. That comes to be rejected. Where is the order, sir?
My lord, the observation is at page number 35, my lord. Last line, my lord. Starts at the last line.
35.
Indeed.
The comes to be rejected by the following order, para 9.
Para 9 and 10.
Yeah, para 9 saako. So the order rejecting the application runs foul of the judgment rendered by this court in the case of Dairy Ice Cream so and so. In that light, the application requires reconsideration at the hands of the concerned court for the aforesaid reasons. The following order: allowed, quashed, the matter is remitted. The application shall be reconsidered by the concerned court strictly in consonance with the law as laid down by this court in Dairy Ice Cream so and so. Ordered accordingly.
Let there be an observation with regard to the trial court need not be influenced by this order.
Which order?
This order is quashed, I agree, my lord, but again,
Brentford. It is needless to observe that the concerned court shall not be influenced by what it had already written.